This was a term that was a little not as, I guess, high profile. There were fewer, so-called blockbusters than there have been in past terms, I think. So this...
Well, on the regular docket.
Yes, on the regular docket.
It's a whole new game.
It's a whole new ball game.
Docket.
Yeah.
Welcome to Cases and Controversies, a Supreme Court podcast by Bloomberg Law. I'm Kimberly Robinson.
And I'm Lydia Wheeler.
Well, Lydia, Thursday was a busy day at the court.
I'll say so.
Yeah. The court handed down 6 opinions. That comes after last week where they gave us 5, 6 if you count the dig. So it was pretty busy. We're going to talk about one of what is probably the most noteworthy cases involving an FBI raid gone wrong. We're going to do that later in the episode. But the court's sort of opinion dump over the last couple of weeks brings us to 21 opinions remaining until the justices wrap up for their summer break.
If they get a break, though.
Right, if they get a break. But that's, I think, because we keep getting all of these emergency requests, particularly from the Trump administration, and they really don't seem like they're going to stop because, lower courts keep ruling against these Trump policies. So we've got a lot on the so-called shadow docket now. Can you kind of tell us where we stand at this point?
Yeah, the Trump administration has filed 19 emergency requests since taking office. 19, including the latest last week, in which the Trump administration asked the Supreme Court to let it keep dismantling the United States Department of Education. And so about half a dozen of these emergency requests are still pending.
Before we turn over to the court's regular docket, something kind of unusual happened at the court last Friday. So the justices, as our listeners know, they have sort of regularly scheduled orders lists that come out Mondays at 9:30. These are the list of cases that the justices are going to either hear or not hear, grant or deny certain these cases. We're at the part of the term where all the cases that are granted are going to be argued next term.
Right.
But on Friday, we actually got the Monday list. The court said that it had experienced a software malfunction.
Whoopsies.
At least it wasn't like a wardrobe malfunction.
Yeah. Oh, my God. Anyway.
All right, so the software malfunction, they said, sent out email notifications early to people who have signed up for them. What happened, Lydia?
Yeah, so this software malfunction caused that anyone who had signed up for an automated alert in these cases to get notice that the court had granted or denied this case. And then after this happened, it wasn't until like 2.5 hours later that the Supreme Court released that orders list to the press. And, legal sources that I talked to said that this could have potentially been pretty bad because this is sensitive information, right? Like that has the potential to move the stock market. That didn't happen here. So nobody seemed to really be all that kind of bothered by this. They just, legal scholars I talked to were like, listen, the court is an institution made up of a lot of people and people sometimes make mistakes. And
I love that. The courts are people too.
Yeah, the court is full of people too, and people make mistakes. But if you'll remember, with the story that we broke last year, around this very same time, the Supreme Court had another whoops, which was they accidentally posted one of their opinions to the court's website before they were ready to. That was that decision allowing for emergency abortions in Idaho. And so it was a really big deal. We actually published, a story about what the court had decided. They hit publish on the opinion and then they pulled it back. And so kind of that sent shockwaves. It's very rare to see the court kind of make these sort of mistakes. And so, that given this, accidental release of, these automated alerts, I talked with Adam Feldman. He's runs the Legalytics newsletter on Substack, and he said that this really kind of indicates that maybe the Supreme Court doesn't have the best controls over its information, because if you remember back in 2022, there was a big leak of their,
Oh, right. That happened.
Yeah, there was a big opinion leak. The Supreme Court's decision or draft decision overturning the constitutional right to abortion was leaked to the press. As you'll remember, the Supreme Court's court-martial did a whole report and made a lot of recommendations. And one of them was, hey, you really need to update your IT systems. They're pretty outdated. And so even though that report was kind of more geared on and more focused on kind of the internal handling of documents, it people are saying like, oh, it did make recommendations that could impact how they release information to the public. So not clear whether or not they followed any of those recommendations or not. There's a lot of unanswered questions here. But the court did announce like, hey, we're going to make some upgrades to the system. We're working on it to fix this software malfunction. And for right now, they're pausing those automated messages. So that wasn't that big of a deal. But let's get into what we teased at the top of the show, which is that decision that we got in that FBI raid gone wrong.
Yeah.
So Kimberly, wow, that sounds bad. What happened here?
Yeah, it was bad. The facts are pretty harrowing, not just as like the petitioners described it, but also as the court put in its opinion. So it happened in the pre-dawn hours when the FBI sort of stormed this home of a mother, her partner, and her then 7-year-old son. Oh. And according to the court, 6 FBI agents, they broke through the front door. They, put off a flashbang grenade, and then they held some of the family members at gunpoint.
Scary.
And then at some point, an officer noticed some mail that had the address of the home on it and realized, like, they're in the wrong home. So they stop the raid. Oof. They do the raid on the correct home. They eventually make an arrest. That person was later convicted. And now the question for the courts is not, like, how liable should the FBI be, but whether or not this family can even have their day in court. So the legal analysis in these kinds of cases is a little chaotic, so bear with me. But I like to think of them as like this on and off switch. So if the switch is off, it means you can't sue the federal government. And if it's on, you can sue the government. And all of these cases start with the switch off because there's this background principle of sovereign immunity that you can't sue the sovereign, and the idea is like U.S. citizens generally cannot sue the federal government, so switch off. But then Congress has passed the Federal Tort Claims Act, which says that, like, in some situations, of course, we want federal officials to be held accountable, right. And we think, like, courts can do a good job of policing that. So it flips the light back on for some sort of situations.
So some people can sue.
Some people can in certain situations.
Got it.
But even within the Federal Claims Act, there are these exceptions that say, like, okay, we don't want courts hearing these things. Like, we'll figure out a way to hold these officials accountable in a different way, and it will flip the switch, like, back off. And I think one of the easiest ones to understand is one of the exceptions at issue in this case was the discretionary function exception. And the idea behind this is, like, if a federal official is just kind of following marching orders, checking boxes, and they cause harm, these are situations where we think, like, the courts will do a good job of, like, holding them accountable. But if there's a situation where it's less clear, we want the federal official to, like, use their discretion, that allowing courts to sort of come in really substitutes the court's discretion for the officer's discretion. And so when you're in one of those exceptions, light goes back off, right? But
here, yeah.
This is why I said it's chaotic. So there's also a proviso to these exceptions. And the proviso that's at issue here was passed in the wake of several really high-profile raids, which, like this case, happened on the wrong home. Oh. And so it says, like, even if you're in one of these, they say that if you're in one of these exceptions, you can't sue the federal government, provided that you can still sue law enforcement for these specific things. So light goes back on, switches back on. Okay, so this involves an Atlanta suburb. So this comes out of the 11th Circuit. So the 11th Circuit said, hold up, even if you're within, the proviso exception, blah, 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 like, and the light is on, sometimes the Constitution, and in particular the Supremacy Clause, requires that the light goes off. So the court in this case said that the 11th, like, it went out of its way to say what an outlier the 11th Circuit was, not just with this, like, Supremacy Clause thing, but also with how it looks at this proviso. And like it said, it's distinctive, which are terms you don't want to be said about you about the Supreme Court or by the Supreme Court. So it said, like, you got this wrong, 11th Circuit. Go back, do it again. And it kind of laid out how it should look at this question. And so we don't actually know if the family can sue, but the court's opinion, in effect, temporarily, at least for now, revives the family's suit, and they're going to get a chance to go back to the 11th Circuit and say, like, hey, we should get our day in court. So
Gives them another chance.
that's a long way of saying that the family won here, but TBD on whether they'll win in the long run.
So that was a decision that we got this week, but we also got a ton of decisions last week as well, including like a string of unanimous decisions. So the court sided with a group of employers that are affiliated with the Catholic Church. These are charities that wanted an exemption, a religious exemption from Wisconsin's unemployment tax program. And the Supreme Court said that, yes, the Wisconsin Supreme Court had wrongly denied these religiously affiliated charities this tax exemption. Then we got another unanimous ruling in a case for a heterosexual woman who was suing her employer for so-called reverse discrimination. So the court said that the federal appeals court was wrong, basically, to require people in these majority groups to meet more of a difficult test to kind of prove their claims than people in minority groups who are the ones that are traditionally subject to discrimination. And then the court, in another unanimous decision, threw out a lawsuit that Mexico had brought against gun manufacturers, including Smith & Wesson, basically trying to hold these gun manufacturers accountable for selling firearms to gun dealers who then traffic them to violent Mexican drug cartels. And there was something really interesting, I think, about all of these unanimous decisions, something pretty surprising, right, Kimberly?
Yeah, I mean, all of these cases were written by liberal justices. So all three of the liberal justices had one of these cases. And I think if you sort of like instinctually think about these issues, like you might think they would have gone out the other way.
Yeah.
Although, I mean, I don't think anybody who is familiar with these cases was surprised by the outcome. But I thought it was notable that the three liberal justices wrote these opinions. And I think it's interesting sort of from a strategy perspective from sort of two ways. So one is from the standpoint of the Chief Justice. So our listeners know that the justice who is the most senior and is in the majority gets to assign who's going to write the opinion. When it's a unanimous opinion, that's the Chief Justice, and he tends to keep a lot of like the big or like closely watched ones for himself. That's like a perk, I guess, of the job. But that didn't happen here, and I thought that was interesting. I mean, especially Justice Jackson, she's the most junior justice, and she's got a big opinion in these cases. So. And then the other standpoint that I thought it was notable was like the strategy of writing these from the liberal justices, because when you write the majority opinion, you have a lot of like leeway as to how broadly you want to make it, how narrow you want to make it, and all of these are pretty narrow. And I think the gun one
specifically,
I think that one is a really good example because like it's a clear loss for Mexico. Because,
definitely.
Yeah, the court said that they hadn't proved their claims here specifically as it related to like aiding and abetting gun dealers selling to Mexican traffickers. So like a clear loss for them. But at the same time,
they didn't go as far as the gun manufacturers had wanted them to, and really close off all of these lawsuits in the future.
Right.
Yeah, so this really leaves the door open for Mexico to maybe try again, or for others to bring similar claims in the future. So the court, really didn't give the gun makers what they wanted, which was like even broader immunity from these type of claims. And we know that Mexico already has another lawsuit kind of waiting in the wings. This one's a little bit different. It's actually against the gun dealers instead of the manufacturers, and that one makes very similar claims. And it's right now in discovery in a federal district court in Arizona. So that's one that we could see come back eventually. And so that was the last decision of the term in a gun case. And, we did a story and talked with advocates on both sides of the gun issue, and really kind of who won, when all is said and done?
Yeah, I mean, there weren't a lot of gun cases. I think as far as like the cases that the court actually heard, there were just two, this one and then the ghost gun cases from earlier in the term, which seems like it was like several years ago at this point. That was before all the shadow docket.
Like advocates that we talked to, I don't know. They called it a mixed bag, I think, both. But if anybody came out like victorious, I would have to say it was like gun control advocates this term.
I think so. And I think the key to that is the fact that the Supreme Court turned away several gun cases. And these, like, notably, the cases that the court heard were, like, Second Amendment adjacent. They really focused on statutes and sort of the text of statutes. The cases that the justices turned away were, like, squarely within the Second Amendment.
And there was a challenge to Maryland's ban on assault weapons, and then there was also a Second Amendment challenge to Rhode Island's ban on high-capacity magazines. And so those are two that the court said, no, we're not going to hear those. But I did think it was interesting that Justice Kavanaugh wrote a concurrence where he basically like invited these disputes to come back and actually cited several cases that are making their way through the lower courts that actually asked this very question. So it's signaled like, he even said like in a term or two, we should take this up. So
although I thought that like that's not unheard of for the justices to do. We see that a lot. Like, I mean, we see calls for that, like with the Loper Bright decision last year. Like, we knew that the justices were kind of like itching to take that case about administrative law, and then eventually they did and came out the way that we would have expected. I thought Kavanaugh's like statement was notable in that it like kind of said what he thinks about this, what is now a hypothetical case. Like, pretty clearly, like he's like the Second Amendment doesn't allow these kind of bans. But I guess we'll see in a term or two, perhaps.
Well, so that leaves us with 21 cases left to decide. And we have just a couple weeks if the court wants to get out of here by June 30th. Do you think that's going to happen, Kimberly?
I mean, I think it's a possibility. 21 seems like a lot, especially if we're just doing one opinion day a week. I mean, you just do the math and one opinion day, even if they're doing 6 opinions, which justices, if you're listening, please don't.
Yeah, stop doing this to us. It's too much.
It's too much. It's like they don't even think about us.
They don't even care about us, Kimberly.
It's awful.
It's awful.
But now actually is the time of year where they start to add like a second, sometimes even a third opinion day.
Right.
Next week, they've just announced one. They've got one coming on Wednesday, which is unusual that it's not Thursday, but Thursday is, of course, Juneteenth, and the court
it's a short
is closed.
week.
Yeah. So they might add another day. I mean, I guess we'll see.
It's always possible that they issue decisions on Wednesday, and then at the end of the day, we hear that there's going to be more on Friday. So, we could end up next week with a second day still,
That.
Yeah, and we have a lot of kind of big ones left. There is that big challenge to Tennessee's law, which bans gender-affirming care for transgender minors. And then we have the other challenge to these nationwide injunctions that blocked the Trump administration from restricting automatic birthright citizenship. So still a lot left to decide.
But, I mean, actually at this time of year, like they've kind of cleared the decks of a lot of their bigger decisions. So.
This was a term that was a little not as, I guess, high profile. There were fewer, so-called blockbusters than there have been in past terms, I think. So this...
Well, on the regular docket.
Yes, on the regular docket.
It's a whole new game.
It's a whole new ball game.
Docket.
Yeah. And we don't know when those decisions are ever coming. Sometimes they come in the middle of the night. So, that's going to keep us on our toes all summer long.
But, of course, you can follow along with all that and the other Supreme Court news at news.bloomberglaw.com. See you next week.